Okay, thank you for listening to Ingram Law. As always, we appreciate you being a guest. Our website is joeingramlaw.com. Our phone number is 205-335-2640. We handle divorce and criminal law cases in Alabama, from Huntsville to Birmingham, Montgomery, and even the Mobile area. If you have a divorce or criminal law case, give us a call and we will try to help you and see if we can represent you. Our conversation for this episode is going to be on why should I have a preliminary hearing in my criminal law case? So, if you are charged with a felony in a county in the state of Alabama, if you're charged with a felony, you are entitled to a preliminary hearing in district court. Now, often and most times, the DA will try to encourage your lawyer not to have the preliminary hearing because in real world there are just more cases than there are bodies. There are more cases than there are time in any given day. And depending on whether you are in Birmingham, Jefferson County, where we have three dedicated district court judges, or as opposed to Shelby County or Blount County, where there's one district court judge, or some other small county where the district court judge does other things besides just criminal law. They will try to really hard for you not to have the preliminary hearing. The exception to that rule is if you are charged with either a Class A felony, which is murder, rape, robbery, things of that nature, or you're charged with capital murder, capital offense. You're always going to have a preliminary hearing in a capital murder case. It's just a given. You're entitled to that. You need to know where you start out in that case. So, the reason I wanted to talk about this today, especially in the last month of March, I have had cases in Coleman. I've had one in Blount County. I've had one in Marshall County. I had one recently in Tuscaloosa County. I had 4 preliminary hearings in 4 different counties in 4 different cases. Now, they were all serious cases. One county is a vehicular manslaughter case. The judge was very good. He granted me a preliminary hearing. The DA gave me 1 police report. However, I went on the Alabama Law Enforcement Agency website, and because it was a death accident, there were 2 other police reports. So we downloaded those. We paid for those. And they helped us at the hearing. It helped us at cross-examination of the witness. Now, a couple rules of the road. At a preliminary hearing, it is customary for the DA, the district attorney, the prosecutor, they're only going to put on 1 witness. Oftentimes, it is the case agent. Joe, what is a case agent? The case agent is the agent for the case that will sit with the state if the case goes to trial. It is their file. They're responsible for everything, the witnesses, the statements, the evidence, chain of custody. They should know that file inside and out. You would be surprised how often a case agent testifies at a preliminary hearing, how little they know or remember about an arrest that they've made, generally within the last 30 or 45 days. Now, the manslaughter case that I have already referenced, the accident happened in November of 23. We did not have the preliminary hearing until March of 24 because we had the holidays, because we had a continuance in January due to a snow day. It got bumped to March. So we've got December, January, February. We had about a 3.5 month delay before we did the preliminary hearing. In any regard, the trooper state agent you think would be on top of this case and know the facts. Cold. No. He had significant gaps. He had significant wrong information in which he testified to. It's good for me. It's good for my client. Because this case probably will not go to trial for at least a year or two. Another rule of the road, always record your preliminary hearing. Now, if it's a Class A felony, you should ask for a court reporter. Generally, if the state has one available, you will have a court reporter there to take down the testimony to use later unless the officer testifies differently. So we had a court reporter in the manslaughter case. Let's go to the second case. I had a client charged in one of these sting operations where you travel to meet a child for sex. You know, however you feel about the charge, my client is presumed innocent, and that presumption follows him throughout the trial. The case agent for that case knew very little about the case. He kept saying, "Can I look at my file?" Well, sure, go ahead. I want you to give me accurate information. I want you to tell me what you know, what you don't know. What are the good, bad, and ugly of the case? You would be surprised what he did know and didn't know, and my client was just arrested 30 days ago. I said, so when my client entered the home, he's on camera. Was he free to leave? No. He was not free to leave. He was in custody the moment he walked in the house. Okay, good. Did you Mirandize my client and tell him that any statements he made would be used against him? No, we didn't Mirandize him. Okay, good. The DA's already conceded that those statements will not come in as statements against his interests because he was not Mirandized. And maybe, if we are very lucky, we can say all the fruit of the poisonous tree should be kept out. All the evidence you can keep out helps your criminal case. That covers that county. Then I had another preliminary hearing. Unfortunately, I've had a string of these lately. I don't promote these. Don't know how I got, hired for all of these. But I've got 3 sex cases right now. So this other gentleman was arrested in another sting operation for traveling to meet a child for sex, solicitation of a minor over electronic means. Again, he goes to the location. he is arrested the moment he walks in the room. I ask the agent, was he in custody the moment he walked in? Yeah. Was he Mirandized? Well, he was Mirandized after we talked to him later. No. The moment he's in the room and he's in custody and he's not free to leave, did you Mirandize him and tell him any statement he makes can and will be used against him in a court of law? No. That information is not coming in. Did my client have any money on him to pay for sex? No. You think that would be important if I went somewhere and was paying to have sex with someone, that I would have actual money in my pocket? Maybe I don't have the criminal intent that you claim that my client has if there's really not any money in his pocket. Did he have any weapons? No. Did he have any alcohol? No. Did he have any pills to, alter her perception to get her to be vulnerable to sex? No. Okay. Another rule of the road, a lot of times when you have these preliminary hearings, they will also be tied to a bond hearing. Oftentimes, when you are charged with a Class A felony, Class B felony that's pretty serious, you will find that the original bond amount is set pretty high. And so you have to go in there and you have to show that your client has significant ties to the community, has a job, has a work history, has ties to the community, to the family. It's not a flight risk, not a danger to the community. Judge, Class A felony should not be more than $60,000 unless it's a drug trafficking charge or capital murder. And so you work your way down to get a reasonable bond. And we talked about this in the last podcast. The case I had in one county in North Alabama, the gentleman that was traveling to have sex with a minor child, we got that bond reduced. I think he was originally charged at, I want to say $500,000, and we got the bond down to $90,000. He had to use a bail bondsman, so he paid $9,000 cash to get out of jail. Was it worth it? Yeah, he's free. We won't go over bonds again because we did that last week. They are a useful tool. Sometimes you have to use them to get your client out of jail. But he's out on bond until he's indicted and we go back to court. Now let's talk about the most recent preliminary hearing that I had in Tuscaloosa County. Client is charged with drug trafficking of cocaine and a number of other charges as well. So the good thing about Tuscaloosa County, from what I have learned and gathered over the last couple of years, have about 5 to 10 cases in Tuscaloosa County right now. Tuscaloosa is pretty good about giving you a preliminary hearing in a criminal case. I don't know why. They're just good about it. And that's great for defense lawyers because yesterday they did 5 preliminary hearings yesterday. They did 4 before me. I was number 5. I was actually impressed with the prosecutor, the judge, and the defense lawyers for doing it. I thought everybody did a good job. So we have our preliminary hearing on our drug trafficking case. And oftentimes the prosecutor will either try to lead or get the officer just to read from the one police report. Make it easy for them. Judge was actually one step ahead of me. He stepped in and said, I'm just not going to let you read from the police report. I'm not going to let you lead him. Ask him questions. I thought, thank you, Judge. Thank you for doing my job for me. By the way, could you slow him down because he's reading really fast and I'm old and I can't hear my left ear? And he said, well, Mr. Ingram, you're just going to have to pay attention and listen up. Okay. But we're recording it. It's on the record. And so, he didn't testify about some of the best parts. They didn't testify that they used a confidential informant to set my client up. In fact, I asked him on cross-examination about the setup purchase. He says, well, I didn't say anything about that. No, you didn't, but I want to ask you about it because it's in your report. DA jumped up. Object, that's beyond the scope of probable cause. I said, Judge, this is a preliminary hearing. I think I'm entitled to ask those questions. He said, well, he didn't talk about it on direct, so I'm not going to let you ask him about it. Okay. I think it's relevant. Need to know. You might as well find out now as find out later. My client's a drug dealer, supposedly. Did you recover any money from his house? No. No money? No. Okay. Did you did you find a safe? No safe. He's a drug dealer. Yeah. Did he have any materials for packaging drugs, such as plastic bags, razor blades, sifters, funnels, glass panes of glass to dilute the product? Well, he had some Ziploc bags in the kitchen. Ziploc bags? You mean the bags that come in a Ziploc box? Yeah. Okay, so that's a kitchen. That is a common item you would find in almost any kitchen in America. Ziploc bags. Does that make you a drug dealer? I don't know. I don't think so. Did you find any heat sealing equipment to package drugs? No. Okay. Did you look to see if he had ownership of the property in a deed? No. Did you look to see if he had any leases in his name that he leased the property that you searched? No. Did you see or did you take pictures for evidence of any utility bills in his name to show that he, lived there and paid rent and paid utilities? No. Oh, by the way, let's go back up just a little bit. Mr. Agent, how long have you been on this drug task force? June of 2023. So not even a year. No, sir. How many drug raids have you done? I don't know, but we've done a few. Okay. How many agents did you take to my client's home? 10. 10 agents for a house. How many bedrooms were in that house? 1. This house wasn't no bigger than maybe 1,000 square feet. And you need 10 agents to go search? What did the 9 other people do? I asked him. I said, did you wear body cam video to record your search? No. Did any of you wear body cam video? No. Okay. And you testified that at 9:03, my client was Mirandized. Yeah. Did he sign a Mirandized warning? No. You just told him he was under Miranda. Yeah. And you didn't record it, so it's really your word against his. Yeah. Okay. I don't know. Maybe we have an issue there with suppressing his statement because there's no record of it. There's no written records of it. It's your word against his. May have to see about that. I found out after talking to my client. Did you know they beat the sheetrock out of that house at the electrical box? They tore that house apart. They walked out with 2 pills, one that tested positive for meth, supposedly. They walked out with some marijuana in a jar. They walked out with maybe, at best, 29 grams of maybe cocaine. Now, under the Alabama definition code, 28 grams is considered trafficking. That's not a lot, folks. You could be making a sale, distribution to somebody. That didn't make you a big time drug dealer. We're not talking about kilos of cocaine. We're not talking about, transferring kilos of cocaine by a car to a location to distribute to vendors that market it on the street. You might be selling to a buddy for personal use. I don't know. Maybe. We'll have to see. Oh, by the way, Mr. Agent, on page 3 of your application and authorization for a search warrant, which you signed under oath, you listed another person and a house, now get this, that is 3 houses down from where my client lives. That's where you put on the search warrant to go search. You listed the wrong name and the wrong house for the search warrant. Judge got mad at me. I don't know. I think that's pretty relevant. You searched the wrong house. Maybe it's an invalid search. Maybe we keep out the evidence from the search because the search warrant is no good. I don't know. We'll see. May have to appeal that to the Alabama Court of Criminal Appeals and the Alabama Supreme Court. They actually read those. And we got a pretty good record to start. So we've talked about 4 different preliminary hearings that I've done in the last month. And it's a good practice if you are a defense lawyer to do those. The one county I was in up in Coleman, the judge even told us after the hearing, he said, that was a really good hearing, both from the prosecution and the defense perspective. He said, it's a tough call. He said, I wish we had more of these. Really? What does that say about the representation of criminals in that county? What does it say about the representation of the lawyers in that county? Now, I'm not going to say that every case needs a preliminary hearing. If your client's charged with a Class C felony, you're going to make a deal. Maybe you don't make the DA mad and waste the court's time if you know you're going to resolve the case and they're going to get probation or not go to prison. Maybe it's not necessary. Okay, that's not what I'm saying. But when you have Class A felonies, serious jail time on the line for your client, their liberty, there are issues at stake as to evidence, collection of evidence, statements against interest, how the case went down. You need to start finding out the facts to see if you can build a defense. What if it was I don't know, an assault case, and your client is telling you, Joe, I acted in self-defense? You need to start building evidence for a stand your ground defense hearing to see if you can get the case thrown out. Had one of those in Bessemer back in 2017, 18. After we had the stand your ground hearing, the DA looked at me and said, there's no way I'm going to indict your client. This case we're throwing it out. It's no good. We got a bad victim. So that's where you start. That's what you do. Oh, I forgot to tell you this. When the DA starts telling you that they'll give you some evidence so you won't have a preliminary hearing, in one of those counties, the DA said, well, if you make me have a preliminary hearing, I'm just going to dismiss the case and indict your client. So you're going to threaten my client for defending himself on a criminal case? I don't know if that's good tactics from a DA perspective. I really don't. Really good DAs that are charged with the prosecution of criminal cases in the state of Alabama that take the case from the arresting officer. If you got a good case, put it on, try it, prove your case. Maybe it makes it easier for me to go talk to my client and say, they got you. I don't think this is a good case for you. Maybe we would resolve more cases quicker. I don't know, maybe. So those are some reasons of why to have the preliminary hearing in a criminal case in Alabama. Now, we're going to talk briefly, and I mean briefly because it is so rare that it happens. A preliminary hearing in a federal case. And you're going to say, well, Joe, why is it so rare? Well, first of all, the U.S. Attorney's Office gets to pick and choose which cases they indict. They don't take every case. They really don't. They handpick the cases that they prosecute. Almost overwhelmingly, the cases come off a grand jury. Your client has already been indicted. They have a trial notebook ready the day you go to the arraignment. They're ready. However, I think in 22 years, I've had 3 cases where I've had a preliminary hearing in a federal case. I had one case where my client was picked up for drug sales, and they were going to make it a federal case. And the agent was just horrible on the stand. The magistrate judge gave my client a bond and said, I don't know if this is a good case or not based on your search. And I think that case went away. The second one I had, they had arrested some individuals in a car. They were traveling across country. The evidence shows that they had a couple hundred American Express cards, a skimmer, an encoder, a laptop in the car. Well, Joe, that sounds like a lot to me. Yeah, it does. Until you start asking the questions of the state troopers that did the search. Where did you find the American Express cards? They were buried in the fender well of the back tire of the car, in the trunk. Oh, so they just weren't sitting out in plain view of the car. No. They were buried in the body of the car. Okay. So you tore the car inside and out to find this. Yeah. Did you take any pictures where you located the American Express cards? No. You're a state trooper, you're an evidence technician, and you didn't think to take pictures of where you found the cards and how you tore them out of the body of the card? No. Jury didn't like that. We actually got a hung jury the first time we tried that case in federal court. Second time didn't go so well. They were better prepared for us. But they did a very poor job of processing the crime scene that they brought to federal court. Maybe they learned from it. I don't know. Haven't had as many preliminary hearings the last 5 years or so in federal court. The third case that I had was a massive drug sting operation. And I want to say there were like maybe 25, 30 people arrested in the same case. And so they put all of us in the biggest courtroom that they could. And so, you got 25, 30 defendants. You got 25, 30 lawyers. Some of them were Hispanic, so you have interpreters there. And you have a U.S. attorney. And they put on one DEA agent who had been running this case for a good while. And you know what? To his credit, he had to answer questions by all 25 to 30 defense lawyers as to their clients' interest or, alleged crime activities in this drug sting operation. And he did one hell of a job. I mean, not one of us could shake him. He knew names. He knew code names. He knew alias names. He knew cars. He knew phone numbers. He knew conversations over wire conversations. He knew who made transactions where. He knew who made purchases where. He knew where people had flew in from, where they had traveled to follow them. I mean, he had his facts cold, and he didn't have a sheet of paper in front of him. That was one of the best agents I've ever seen testify. He was articulate. He knew his facts. He knew his evidence. They had a really good, strong case. That preliminary hearing lasted, I'm going to say, about 6.5 hours without a break. And he was on the stand for 6.5 hours and stood up to about 25 or 30 defense lawyers. That's a pretty good case for the U.S. attorney. So you're not going to see that often in federal cases, preliminary hearings. Most of the time, you have to do suppression hearings. So that is a brief rundown of why to have a criminal preliminary hearing. I would encourage lawyers to do that. If you are charged with a crime, you need to ask your lawyer to do it or ask them why they're not going to do it. I'm actually doing another preliminary hearing next week down in Marengo County. And I called ahead. I talked to the prosecutor and I said, hey, am I driving for nothing? Or are you going to put a live body on the stand? The DA was very cordial, very nice, said, yeah, we're going to put witness on and let you have your hearing. I said, okay, thanks, good. That helps me out tremendously. So it's worth the time, the effort to have the hearing, to find out the good, the bad, and the ugly of your client's case from the start. As we always say, this is Joe, IngramLaw.com. Phone number is 205-335-2640. We take cases in Huntsville, Birmingham, Montgomery, Mobile, Dothan. We take cases in Walker County and Winston County. I like going up to Walker County up Corridor X. So if you have a divorce or criminal case and we can help you, please contact us off the air and we will get back to you. As we always say, take care of yourself and each other and have a good night.
No representation is made that the quality of the legal services to be performed is greater than the quality of legal services performed by other lawyers.